Yo, it's showtime. What's up? Welcome to Just Facts, presented by Defense Diaries. I'm back. So it's been a long day, as you can imagine. I drove to Delphi last night. Oh, boop, there she is. And woke up at like 5 because I never know. I never know how many people are going to be there in terms of trying to get into the courthouse. And obviously, I'm not getting shut out, so I have to make sure I get there early. And it was freezing. And, you know, we had to wait for 3 hours in the cold. So it's been a long day. And it's been a disappointing day on top of that. But I love you guys. So we're doing this. We're going to do this damn thing. And just some ground rules kind of moving forward, because we do, as you guys know, first and foremost, we are a podcast, Defense Diaries podcast. If you don't listen to it, you really should. It's not just Delphi content. Obviously, we try to crush that as much as we can, but we have serialized seasons. My father was Gacy's attorney back in 78. That first season is epic. The second season is a case that Allison and I handled, and it was a nightmare, very similar to Delphi. Not necessarily the fact pattern, but kind of how it went down, and it was brutal. It was a war, a lot like this, a lot like what's going on at Delphi. So you might want to check that out. What's up?
You set the time and day right for this?
Yeah.
I'm seeing something that says tomorrow.
We have a live with Maggie Freeling tomorrow.
Ah, okay.
Allie's on top of it, but she's working, y'all. She's got a real job. So I had to rip.
Well, I don't see anything on here, but.
Is your mic plugged in? Because you sound more echoey than normal. And make sure that you go into your. Oh. Sorry, guys. We're still gonna have hiccups. I still have people saying, "Oh, you guys have hiccups," and I'm like, "Deal with it. Like, we'll get better. We're doing the best we can." So try.
My mic was backwards.
Oh, that helps. It helps if it's facing your mouth. Little tip from a guy who does some podcasting. So, at any rate, what we're going to be doing, like from moving forward, is we are going to take questions in the middle for continuity's sake for my editor, Darren Wood, and my executive producer. It's easier for him if I can just have a section that we can pull out of the podcast, because for continuity of the podcast, it doesn't make for good listening when we're answering questions in the middle of the podcast episode. So we'll do it in the middle, and then we'll do it in the end. We'll do acknowledgments as well. If anybody's kind enough out there to donate to us or give, be gracious enough to send us money and things of that nature, or get memberships and all that great stuff. We'll give those acknowledgments at the middle and the end as well. So I don't want anybody out there thinking that we're not going to be given the love, because we'll always be given the love, because we're super appreciative of it. And frankly, it's why we do this. It tells us that you enjoy the content, and it means a lot to us, because this is a tough gig coming on to do these lives, and in cases like this, where there are two very distinct camps, I am obviously a defense attorney by trade, as is Allison. And obviously that is what my thought process runs through. always. Now, that does not mean that I'm not objective. I am. That also does not mean that I don't have opinions on this case, because I do. But that also does not mean that I don't acknowledge that there are opinions that are valid on the other side of it as well. So we're trying to address all of it. And I don't want anybody ever getting the feeling that I'm poo-pooing anything, or I'm saying that something is ridiculous, or because at the end of the day, again, and I say this every live, because I want it pounded into everybody's skulls. The only thing that really, really matters in this is justice for the girls. So these entire conversations that we have about Richard Allen, because tonight we're not going to be talking about innocence or guilt. We're not even close to that phase of this case yet. Not even close. It'll be a very, very long wait for y'all if you're waiting for me to talk about, the facts of the case in terms of proving innocence or guilt, because frankly, we don't know them. So now's not the time to talk about them. Now,
All right. So why don't you, sorry.
Remember, I gave you, you got to do a signal, like just do me a little thing and I'll stop talking. I'll let you jump in. What?
No, I forget what I was going to say. Go on.
Okay. So I forget what I was saying. You literally.
You were about to just tell everybody what happened today.
Well, I wasn't quite there yet.
You know me, I'm always jumping ahead.
Well, we ended up getting, like I told you, about 1,500 new subscribers today. So
you want to say hi and introduce us?
Well, yeah, and kind of let them know what the show is all about.
What we're all about.
Right.
All right.
Do I have clearance on doing that, babe? Thanks, honey. All right. So, but I don't want to waste a bunch of your time, and I'm exhausted. So I'm going to do this as long as I can. But I do want to give you, I did an earlier live outside of the courthouse.
I haven't even watched it yet. I've been so busy.
I know.
I mean, were you excited during it?
I was not. I was actually pretty morose. I was the opposite. I walked out of the court.
Well, I didn't mean like excited, happy, but just like over what the judge did, like just over everything.
No, it had the opposite effect. I mean, I wasn't fired up at that point because I was still kind of stunned at the way that it all went down. And that's kind of one of the things that I want to try to focus on tonight, because, I've got, a friend from the other side of the aisle, Brett Talley and Alice, who are the Prosecutors Podcast, and they have a very different position about this. And I respect them. And I respect their intelligence. I mean, they're both highly educated. I think Harvard and Yale. And I have a very different view. And that comes from the fact that prosecutors and defense attorneys have very, very different roles in terms of the criminal justice system. Prosecutors are subjective in nature. That is the nature of their job. They have to focus in on one person and one person only. Once law enforcement comes to a prosecutor and says, okay, this is our guy and this is the evidence we have, the prosecutor is not saying, well, could it be somebody else? They narrow in. They tunnel vision immediately occurs, and that becomes their person. So there is no subjectivity or objectivity with respect to a prosecutor's job. And that's no fault of their own. It's the nature of what they do. For us as defense attorneys, it's the exact opposite. We have to be objective because we're getting the same evidence. We're looking at it. And I have a client who's saying, I didn't do it. So I have to be objective and say, okay, well, let's see who else could have been responsible for this. So there are two very different trains of thought that when you do this job for years, like any job you do, but this is like, people are always like, what do lawyers do? Like, why would we pay them all this money? Because they don't do anything. There's nothing tangible that we can touch. They don't do it. Like what, it's a very intellectual job in the sense that most of it's done up here. Like a lot of our job is thinking, obviously with writing and preparing motions and petitions and things like that. But a vast majority of it is in our minds. So, when you do it for 20 plus years, that's the way you think. So that's the way I think, but the fact of the matter is objectivity is part of my job. So I try to be objective. That doesn't mean that I don't have opinions. And again, it does not mean that you have to agree with everything I say or anything I say. And I encourage people in the chat, at least if you're going to be civil and not going to be name calling. Like that's one thing I just won't have it in the chat. If you can't have a civil discussion, then we're not the channel for you. You know, we're really not. If you can give an articulate argument and you have a discussion and you want to go back and forth, I'm all about it. It's what we do for a living. I love that. To me, it's the spice of life. So I encourage it. And I want you all to do it in the chats because this is one of those cases. And we're so early in it.
Right. Just be open to everybody's opinion and
you
have
don't
some
even have to
leeway
be
for it.
open.
No, but I mean, like, have leeway for it. Like,
just be civil. You know,
okay.
like just that's the bottom line. Be kind. You don't have to be like a raging a-hole to somebody else that you don't agree with. You can use your words and just be kind. It's simple. I do it all the time. Believe me, if you follow my Twitter account, which just I broke 10,000, babe. You know, I'm very active on there, and I have a lot of people that don't agree with me, and I never devolve to name calling ever because I don't need to, because I can use my words. I can make my arguments. If we agree to disagree, I tip my cap and I say, good day, you know, I mean, that's it. It's over. You know, it's like, it doesn't have to be ugly. Let's change the narrative. Let's change the vibe on the internet, at least on this channel, in terms of being toxic. Because I don't want it. I don't want it on this channel. I don't want it in our insiders group on Facebook because it makes your life miserable. Like why do you want to go online to be made miserable by other people that you really don't know, talking trash and name calling? I mean, that doesn't sound enjoyable to me. So I want to keep this. I want to keep this kind, civil, intellectual, because I think that's the type of show that we have. So enough. I'm off my soapbox. Sorry about that. But it had to be said. So yeah, this morning I get in there. They let us in at about 8 o'clock. I'm seated. I happen to be one seat over from David Hennessy, who is Andy Baldwin's attorney who filed the petition for the writ of mandamus. I happen to be a couple seats over from Kathy Allen and Rick's mom. And then I, so I was chatting with David Hennessy, and if you're not familiar with him, he's longtime pit bull criminal defense lawyer in Indianapolis. Allie, he actually knows Chris Eskew, a friend of ours, another criminal defense guy in Indy. And if Chris happens to watch this ever, Hennessy said, "What up?" But it was interesting. It was, I wouldn't say I was getting inside intel, but it was interesting sitting there with a fellow defense attorney because he asked, what my background was, and I said I'm a longtime lawyer as well, criminal defense guy. So you always have kinship when that kind of happens. So it was kind of interesting to be able to sit with him and kind of get his, I would call it color commentary as this thing was going on. So we're all in there. Thing's supposed to start at 9. 9 comes and goes. 9:15 comes and goes. 9:30 comes and goes. 9:45, Gull finally decides to come out of chambers. And she wasn't back in chambers with anybody. She was back there. She came out. But before that, and we had heard the rumors last night, and I had posted on Twitter or X, and that the rumors were out there. There had been an unfile stamped copy of Baldwin's entry of appearance pro bono for Richard Allen. And I heard, another report that Rosie had filed one as well. I got confirmation before we went in this morning that it was true. I knew for a fact that Rosie and Baldwin were both coming in. So I was telling the people in line, I'm like, yeah, they're going to be here. Because they're like, are they going to show up? I'm like, of course they're going to show up. They're attorneys of record again. And I'm trying to predict in the beginning before they come out. So those guys are sitting in the well of the courtroom. So you got McClelland and Luttrell, who's the guy for the prosecutor side of it that just entered his appearance as well. I think he's a seasoned prosecutor. Somebody from up on high must have said, you know what, we're going to give good old Nick a little help here. So they brought this guy in. And I don't see the new guys at all. So I don't see Scremmins and Librato, I think his name is. If I'm butchering that guy's name, just let me know in the chats. So I don't see them at all. I don't see Allen at all, and this is leading up to the 9:45 time, but I do, like, I'm watching Baldwin and Rosie just kind of sitting there chatting back and forth, Hennessy calling Baldwin back, them chatting, and I asked Hennessy, I'm like, because like, just so we have a clear understanding, despite the fact that the petition for the writ of mandamus was filed in the Supreme Court of Indiana, that is not being heard. That has nothing to do with what's going on in Carroll County on today's date. That's a different courthouse, different level of courts. So, that is a completely different issue. However, he was there because it's intertwined with his representation, because if you recall, David Hennessy had filed a memorandum on behalf of Baldwin in this case, relating to his representation of Richard Allen. So he was there in that regard. There's one thing, and there's just a lot of stuff going back and forth. And I happened to watch Brett's live last night that he did for his patrons, and Alice wasn't on there, so it was the Brett show. And I'm like, I like to listen to it because I like to hear the opposite side of it. I enjoy hearing the opposite side of an argument, because if you don't know what your opposition is saying, I don't know how you form an argument to try to defeat it. If you're going to just sit there and try to yell over somebody or call somebody names without knowing what they're saying, it doesn't make for a very good argument. So I enjoy listening to what he has to say. I'm sitting there talking to myself for the entirety of the hour-long live while I'm driving down to Delphi. I'm like, you're nuts, you're, all this stuff that I'm doing, but that's me on my own. So, but I think that there's a portion of society, and again, I'm not talking about innocence or guilt here at all. Okay. I'm talking about what's going on procedurally in this case. That is what we're here to discuss tonight. Down the road, we'll definitely be talking when this thing's at trial, and it's going to go to trial, whether it's going to be Baldwin or Rosie. And believe me when I tell you, that is not over. Okay. I know that you think that it might be over. It's not over. And we'll get into why I think that a little bit later, but it's not over. So at any rate, Brett talks about certain things, and he's breaking down kind of like the timeline of what we're going to be talking about tonight, which is due process. And did Richard Allen have due process under the law? Did he get notice? Was there actually a DQ hearing that took place? How were these guys? We can argue all day about whether or not Baldwin and Rosie withdrew without being coerced, or whether they were coerced, because there's two different camps there. The side on Brett's argument is, okay, well, they knew about it going in. They had a chain of emails starting on, I think, the 8th, where this thing starts to percolate, or the 6th, maybe even before that. I'm not going to pull the emails up because we've already done that, but there's emails between the judge, between McClelland, between Rosie. So it's out there, and like the concept is out there. And as we know, if you remember one of the emails, it states that from Rosie to the judge, where he CC'd McClelland. And Brett said he found that unusual. Now in our county, we the judges allow us to email, not as a normal course of business, but in situations where if we have trials coming up, or we're in the midst of something.
And it's gotten much more prevalent since COVID.
Yeah.
I was almost never, like, the way I can email a judge now is not the way I could email a judge before.
For sure. Yeah. When Zoom became a thing for courts, that, it brought us, it kind of forced the legal game into the tech era. And, so we're taking advantage of those things, but so it's not unusual. Like Brett was like, oh, I've never had like any kind of occasion to be emailing judges. So maybe that's a Southern thing. I don't know. He's down
Yeah,
in
I mean, it's
Alabama.
definitely, I think it's more prevalent in bigger cities, more metropolitan cities, because the judges are busy and it's easier.
Yeah.
Um,
I
but
mean, and it's convenient, It's like my father hated the advent of the fax machine because he's like it sped the practice of law up exponentially,
right.
Which makes sense. He's like, it's so fast now. I don't understand why it's so fast. So I'm like,
All right.
so as far as Brett, but so his argument is that they weren't blindsided. Okay, that they knew going into that hearing that there was going to be something of that nature.
And we raised that issue. There's a difference between not being blindsided and having due process by way of a meaningful opportunity to be heard.
Right. Well, and beyond that, I mean, there's rules of criminal procedure. Like we're not living in the crazy world where there's no rules. I mean, if I had my little Lebowski sound pad thing, I'd be playing the clip where he's saying there's rules. Mark it 0, dude, because this isn't Nam, Smokey. There's rules, and just like that, there are rules. And using the word ambushed or blindsided in the typical way that we use it in our normal everyday language is different than it being applied to the law, meaning that you were ambushed legally, meaning that yes, they clearly knew that this was an issue coming up, but they get an order from Gull. She doesn't mention anything. The only thing that they had heard about a DQ is that Gull said that McLeland said that he wanted to disqualify them. And that was in one of the emails. However, it's never filed. There's no motion filed. Okay. In the practice of law, again, and I'm always beating people over the head with this thing about the record, is that you have to file documents. You have to file motions and petitions because that's how you make a record, right?
Yeah, absolutely. I mean, the judge can, I mean, the issue is not as much of, did she file a motion? Or, I mean, obviously that is important for the record, or at least to otherwise get it into the record. But it's not giving them an opportunity to be heard. Like just letting them know that this is like an issue and we're going to discuss it doesn't mean we're going to decide it right then and there. They should have still had an opportunity to address her complaints and present either evidence to the contrary or whatever the case may be.
But well, they didn't know her complaints until the morning of the 19th.
Right. No, that's what I'm saying. That just.
Well, you seem to be excusing her a little bit and saying that, but I think that she can make a motion, a sua sponte motion. I think that there has to be a motion made. Don't you? But it goes to what you're saying.
Yes, oral or written, though, either way. But what I was really trying to do was counter what you said, the prosecutor said, in that, again, and I'm repeating myself, not being blindsided is not the same as what is needed to constitute due process as far as notice and a opportunity to be meaningfully heard on the issue. But I mean, just saying not blindsided, that I don't know what that satisfies.
Right. I mean, that's what I mean. It's like we're talking about the law here. Like, yes, they had knowledge that there was an issue. Frankly, it was Rosie that brought it to the judge. So clearly he knew there was an issue. So that argument just falls on deaf ears because ultimately, when you get to that issue of the 19th and what happened back in chambers, which I cannot wait. The best thing that Hennessy told me, and I shouldn't even say it on live, but I don't even care, is he told me that in Indiana that the public can file a precipice to listen to the audio of what happened back in trial, that it's a public right. And I told him we want to do it. So I think I'm gonna Maggie Smith, who is the woman who prepared the writ of mandamus. I think that she'll help us get that done. Like I really want to hear what happened back in chambers, because it was not a pleasant conversation. You know, it's like Brett and some of the people that hang out in his echo chamber. Like I keep hearing, oh, she gave them the courtesy. She gave them the easy out. This was not that type of conversation. This was a or else type of conversation. This wasn't, oh, I'm trying to do you the kindness of avoiding being pantsed in public.
Right. Well, we kind of raised that and said she could have presented it as I'm doing you this favor, but nonetheless, it has the same effect as, you know, coming at them hard. I mean, until we hear it, I guess we won't know. But either way, it's either just a nice way of presenting the very same alternative of, you know, quit or get fired publicly in pants.
So that's what Hennessy told me, exactly what Rosie said. Like verbatim, he said, so Rosie said, so let me get this straight. You're basically telling me quit or you're firing me. And she said, that's right. So that's
well, it doesn't sound very polite and courteous.
Well, I just told you it wasn't polite and courteous.
No, I know. I'm just agreeing with you.
Like the one thing I'll tell you in terms of the just facts thing, like when I'm telling a story like that, I'm not making it up. I've got it from like on high from a good source, somebody that actually knows. That actually occurred in the courtroom. That's the only snippet of what I know took place back there. So this was not again, it was a Hobson's choice. But the bigger issue, that forget all that, is that Richard Allen was not in the room at the time. The defendant, the guy who has the rights in this, because he's the one going to trial. The Constitution and the rights that come with it apply to him in this case, and no one else. Like he's got the rights in this case, and that is a critical stage of the litigation, and he was nowhere to be found in the chambers. No one spoke to him about it. Like this was all going on without Richard Allen, the guy whose life is literally on the line, having no knowledge of it. So that's where the issue comes up. That's what the real issue is, that people need to understand, because, all right, whatever. So at some point, so she comes out, she says, okay, look, we've got McClelland and Luttrell on behalf of the state, and we've got, and she goes right to Scremmins and Librado first, and then she says, oh, and I see late at night last night that Mr. Rosie and Mr. Baldwin have entered appearances pro bono as private counsel for Richard Allen. And then she just and then she asks Librado before she does anything else. She says, Mr. Librado, I've heard that you'd made a motion to, so she establishes who she's dealing with, like right out the gate. And she asks Librado, I heard that you filed a motion for a continuance of the trial date. And Librado, who's sitting not even at counsel table. So you got Rosie and Baldwin sitting at counsel table, and then you got Scremmins and Librado, and they brought, I guess, a female investigator for some reason who was sitting in the wall of the court next to him. And Librado stands up, looks super nervous, you know, and he's kind of a short little guy, and he's like, oh yeah, Your Honor, yeah, you know, we're just getting into the case, and you know, there's no way that we'd be able to go in January, so yeah, we're asking for continues the trial date. She says, Mr. McClelland, do you have an objection? No, Your Honor, we don't have an objection. Obviously, they're new to the case, blah, blah, blah. So, you know, and then she asks Librado if he's got an idea of how long he needs to go out before they can, you know, set it. So he says, yeah, you know, he's talking November. She ends up setting it for October 15th. So the new trial date is October 15th. She anticipates a 2-week trial, which is insane. There's no way this is going to be a 2-week trial. This is going to be a month or longer for certain. You know, I mean, in terms of how she ran her docket, if that's how she's going to run a trial, it's going to be a thing. Especially if Rosie and Baldwin can fight their way back in, which I'm just telling you, you heard it here. That fight's not over. But so she has these guys establish on the record that, they're the dudes now. Okay. And then she just sits there for a minute at the bench and is like, oh, Mr. Rosie, what can I do for you? like that. He stands up and he's like, well, Judge, I've obviously we've filed our motions or our appearance in the matter, and we consider ourselves to be counsel for Richard Allen. As you're aware, Richard Allen has written a letter to Your Honor, which was obviously drafted by the lawyers. Like Brett's like, oh, this clearly wasn't written by Richard Allen. Well, yeah, obviously. I mean, I don't think he has a computer in his cell. So it was obviously written by somebody else, but it was signed by Richard Allen. And I think that Richard Allen's intentions were included on that letter. I think he said, I want you to be my lawyers. And they took it from there. And so, he said, so that being the case, and he's trying to make a record here. You have to understand that because of what went down with whether or not Rosie actually withdrew is still at issue. Like in Rosie's mind, not in the judge's mind. The judge, you're done. You're both done. You're out of my face. You're here, but you're not here, and that's her mindset. Rosie's mindset is, well, we've now entered our appearance as private counsel pro bono. This is who our client wants us to represent him. And that's it. Like there's no further argument, just have these two guys behind us withdraw and let's keep plowing on. Like Allison, you told me when I got home, what would your move have been had that been us in that situation?
I would have filed is that what you're talking about? That I would have, if I walked into the courtroom and I had filed my appearance, what I would have done, and I was, those of you who have been listening to us for a while know I kind of jump ahead. So I was trying to get to all right, just give me what happened. But I was noting that I would have just walked up and addressed business as usual. I would not have addressed my appearance. I wouldn't have said anything about my appearance. My appearance is on file. I'm the lawyer. So I'm going to say what I would, had nothing about the appearance ever been happened. And then, I'm sure it wouldn't have changed anything, but the judge would have had to address it sort of differently, would have put her in a,
different spot for sure.
Right.
Yeah.
Just address the order of business, whatever right. It was you wanted to address.
Let's get cracking on whatever hearing that you had set up for today, which of course you didn't put in the order. None of us know what this hearing was going to be either. So, and that's one of the things. And I believe, Allie, I think that the Supreme Court already issued a writ. It came down. I was asking some of the folks who had posted it if that was like an official writ. I'm going to throw it up in the event it's authentic. But it's interesting. It's like they had thrown an order out right away, saying, okay, well, the state's got 9 days to respond, and then we'll issue a ruling on it. But it appears that something came out today before court. And it's not in favor of Gull. And I think that kind of is the overarching theme of what's going on with this case and whether or not she's fit to be on the bench in this case. I think that we cannot forget that the Supreme Court of Indiana now has their eyes on this case more than they would have prior. Obviously right now, this is the biggest case in Indiana, maybe in Indiana history. So it was on their radar, but now
I see nothing new on the docket today, on the Supreme Court's docket.
All right. Well, since I think it's kind of interesting, I want to just throw it up anyway. I'll let you take a peek at it. Let's see if I can see what you think. It's a strange blurry copy. So I don't know. Like that's why. So we're giving you this one with a permanent or a grain of salt.
An asterisk.
Yeah. I mean, it certainly reads like it.
Verified supplement. What does it say? I can't see that.
All right, I'm gonna read it.
Just give me the caption. That's all at first is all I'm saying.
Wait, it's got the wrong damn thing up there.
No wonder.
That's weird. All right, I'm screwing up. This is like somebody's like, hey, you guys really need to figure out your tech side of this because it'll make the show better. I'll figure it out while we're going. I'll read it to you. It says it's therefore, or because it is a very blurry document.
What is the date of it?
It is dated. Yeah, that might be a clue. And it's weird because it's got Scremin listed on there too. Yeah, I don't know. I don't know if it's legit because there is no date on it, but it doesn't.
How about you email it to me?
Okay, I will. All right, but I'm not going to do it while we're on the live. All right, okay. So at any rate,
if you wanted to figure it out while you kept talking, I'd look at it.
Yeah, I mean, I don't want to be wasting
Save it for next time,
like us trying to figure stuff out. So at any rate, Rosie stands up and he starts going through it, and he makes the argument because and for people that don't understand the Sixth Amendment right to counsel, we went through it, so I'm not going to belabor the point.
No, I think this is actually the most interesting part of what you're explaining to them.
Okay, well, I want you to explain right. Well, I mean, like we had a lot of viewers last night. We got a lot of viewers tonight. And by the way,
right, but I think that there's a way to, but it doesn't make much sense until I guess you tell everybody.
Well, I mean, I think right now, so he goes into the sixth argument, the difference between the fact that now he's private counsel and that, he came on pro bono. And this is who Richard Allen chose as his attorneys. It was his choice this time. They weren't appointed. He wasn't just handed two lawyers. You know what I'm saying? So that's the art. So he goes into that right away. So what's the significance of it?
So, and we've talked about this before when Bob and I were both saying the only way for Baldwin and Rossi to get around what the judge was doing was to just pony up and enter an appearance pro bono, not waiting to be court appointed. So they did that. So now that they did that, the defendants, there's no question because, there's not a clear cut when it comes to being represented by a court appointed lawyer. You don't have the right to choose which lawyer is going to appoint you. However, there's a very strong argument to be made that you have the right to continued representation by the public defender after the specific public defender once that person is appointed and starts representing you. But there's a much more clear-cut, recognized, undeniable right to your counsel of choice when it is retained or pro bono counsel. So, and that's what they had here. So in the situation that we're dealing with now, the court has absolutely, positively no ability to do what she just did without giving the defendant the opportunity to be heard and to waive any potential conflicts and all of the things, because this is what's called a structural error, denying a defendant his right to counsel of choice. And that's it. I mean, if the court weren't to address this now and he were found guilty, he would almost 100% be getting tried again. Because with a structural error, that's what they call it in the law, you don't have to show prejudice. It's one of those situations where it's like, per se, you screwed up and this guy gets a new trial. Because there's no way for a judge to figure out what another lawyer might have done differently or how it could have changed the trial, or in that situation, in the situation where the defendant is denied his right to counsel of choice.
So in terms of case law that you've looked at, because I was asking you about the continuity argument, and I can't remember if you were on the live or if you had to go the other day where I was talking about the continuity argument with respect to appointed counsel, and that it's been the law of the land for a long time that when you're appointed counsel, meaning if you're indigent and they appoint a public defender for you, you don't get to pick and choose. And what the continuity means is that once you're deep into the case, and they're trying to remove that lawyer, the law has been that the judge is within their discretion to remove that lawyer, and the defendant doesn't really have any say so over it.
I disagree. So that's what I'm saying, that, and I actually sent you some case law on this. There is a split in the circuit, and there is a very firm legal argument to be made that a judge on their own, unless requested by the lawyer or the defendant, cannot remove the counsel, cannot deny you your right to continued representation by the attorney who's representing you, by your court-appointed attorney.
When did those cases come down? Are they recent?
Well,
I'm only asking because I'm saying historically it has been as such, where they weren't really giving much.
So when I say there's a split in the circuit, for all you viewers out there, that means that different federal courts are treating it differently. So in the Chicago area, well, in Illinois, we are in the seventh circuit. So our courts can handle things one way, and then another circuit can handle it completely different. So when you say there's a split among the circuits, that means not all federal courts are treating a situation the same and applying the Constitution the same and coming up with the same result. Yes, as I started this, you don't have a choice. You can't make the argument that you have a preferred court-appointed attorney. You don't have the right to be appointed the attorney of your choice. But again, I still think that once you have a relationship established and they are your attorney, that I have seen law that speaks to, and again, it depends on the circuit. And that's why I started by saying there's a split that supports that the judge can't on their own. If the attorney asks, sure, then the defendant's right, can take a back seat, but for the judge to do it. But again, that's why I started by saying you're more firm footing when you're dealing with private counsel, your right to choose. There's no questions, there's no split, there's no pause. 100%, you cannot be denied your counsel of choice without due process and damn good reason.
Right. And so, I'm obviously devil's advocating for you. And the reason that I always bring Brett up is because Brett's the voice out there and I'm just telling you, his opinion is the exact opposite. He says that there is no law.
Well, guess what? I'm right.
All right.
So would I stand here and tell you that there's a split in the circuit?
Hell no. Hell no. I'm not questioning you. I'm just telling you, like, I'm devil's advocating that's what Brett's saying. And I mean.
Well, but he is right in the sense the right to continued representation of your preferred counsel is not as strong as the right to retained private counsel of your choice, but there is a basis in the law, for it, and more circuits are starting to follow it. And
well, he's not even giving you that not as strong. He's saying it's not a thing.
All right. Well, when we hang up, I'll send him some case law.
All right. So, which leads me into the next question I have for you. So when Baldwin and Rosie come in on this day, how does that bolster the argument? So
it changes everything. That
like immediately,
immediately.
Because they have that past relationship and they've built that.
No, not even that. Because it is their private counsel of choice. He has the right to have whatever lawyer he wants, as long as they're licensed, obviously. And, a judge won't let like some civil lawyer come in and do a criminal case, but there would still be some sort of a hearing. So no, by filing their appearance and by him being Alan, stating on the record that this was his counsel of choice, and the judge saying, I'm not letting this lawyer represent you, she has 100% violated his right to choice, counsel of choice, without due process, without a hearing, without nothing, regardless of what went on on before without at least, again, the opportunity to be heard. And she'd have to find that there were certain conflicts that were not waivable. What I haven't researched is this, which I told you last time when you talked about the findings, but I guess I'm getting ahead of myself.
Yeah, you're getting ahead of yourself. So
just give them the story, the quick end.
This is part of the story. This is the argument. So Rosie stood up and said this stuff.
I understand that, but let's just tell them what happened and then we'll make arguments.
So after Rosie does that, the judge says, okay, well, I understand that, but I'm removing you because I found your representation of Richard Allen to be grossly negligent. Flat out. She just says, I've made a finding that your representation of Mr. Allen has been grossly negligent.
And that's the aspect that I have not had a chance to research. When a judge makes a finding, and let's, for the present point that I'm making, assume that she's actually able to make that finding without giving the defendant and his counsel the meaningful, opportunity to be meaningfully heard. If that, I'm sure it goes over what types of things fall into that in order to circumvent or interfere with the defendant's right to retained counsel of choice.
Right. So that was her counter, and in her, so she just goes and says that and she speaks for 5 minutes, repeating over and over, you both withdrew. I gave you a choice of either coming in and telling you, and she admitted it on the bench. She's like, I told you I was either going to disqualify you in open court, or I gave you the opportunity to withdraw, and you chose to withdraw. And I didn't have to put that on the record. So, meaning in the well of the courtroom, that she didn't have the hearing that they were set to have. I mean, again, even on the 19th, there was no notice of it. They weren't prepared for it in the sense that there was a motion on file. There was just no, they didn't know what the allegations were. They had no idea going into the 19th what they were alleging, other than the fact that there had been a leak. And what McLeland had said in the emails, okay, this is what this dude said, and this is what this dude said. Okay, so those are the facts that they've gathered, but that doesn't mean that that's what the allegations are, because there's a difference between whether or not Baldwin knowingly gave the discovery over to somebody in order to leak it out, because there are plenty of people out there that think that that was their move, that they planned this, that they wanted to bolster the memo. They wanted to get these pictures out to the public in order for the public to be able to see, these are runes, and that's why they did it. And then
she said this?
No, there's a camp. There's a camp out there. There's people out there but it needs to be addressed. This is part of the platform that we have. I
understand. And I would love to address it. I think we have on other lives, but I would address it again.
Well, I'm just saying that's one camp, which is the knowing, willing, the willfulness and the knowing of turning over protected discovery in a case is egregious. Okay, that I think would rise to the level of being removed from the case. The other camp is he's reckless, that they had a war room, that they didn't have all the discovery under lock and key, and then some guy crept in there under cover of darkness and took pictures and then disseminated it. That's a very different thing. And they didn't have knowledge of it when it happened. It's not like they knew about it right away. They had to, how would I know if, and I'm just saying, when we had our war room for Garcia and we had 8, 9, 10 people working in that office, any one of our employees could have taken pictures. And even if during the workday, and I wouldn't necessarily know about it if that's what their intent is. I mean, can you, are you blaming a bank? If a bank robber comes in and steals the money, I mean, is it the bank's fault? Well, yeah, we had security, but you know what? They had guns, so they came in and they forcefully took the money. And I mean, you're casting the blame on the person in terms of, and there are no rules that exist, ethically or otherwise, in terms of You know, the protective order was the rule of that. And it was just, don't disseminate it, you know, make sure that people that have access aren't disseminating it. You know, there was no keep it in a gun locker or a gun safe, you know, that you have to lock it down every night, that you have to clean up your war room every single night after your day is done. And I mean, could you imagine us cleaning up our war room for Garcia every single day because we're worried somebody's going to take a picture of Discovery, which
no, you just had to lock that room.
Right. Which I don't know that he didn't, you know, which is the point, that there was no hearing. None of the facts came out. None of what happened or what could have occurred was ever heard by anybody. So everybody's left jumping to conclusions. Period.
I was going to say, presumably the judge heard it in chambers.
I don't think so.
And it's in Hennessy's motion, you know, to a certain extent.
At that point, but she had already had a pre-written little bullet point memorandum that she handed to Rosie and Baldwin when they walked in on the 19th at 12:30 p.m. Said, here, you either withdraw or I'm going to go into the court on live TV, which I just allowed the cameras in for the one and only time. You know, I mean, like, that kind of move shows you her mindset. The fact that there's been no cameras at all ever and probably will never be again, but she made sure to have the cameras set up for that day. I mean, it shows where her mentality is on this thing. Like, if that doesn't seem coercive to you, I don't know what does. Like, honestly, like, forget about anything else. Just put yourself in that position. It's like if you're in an argument with your spouse or your boyfriend or your girlfriend and they start filming you, you know, you immediately change your behavior because you know you're being filmed. It's like, it's a very coercive act. You know, and it was a coercive act for her to have done that, in my opinion. So she goes through her thing. She basically says, screw you guys. She says, Mr. McClelland, do you have anything to add? He's like, oh, Your Honor, I agree with Your Honor. I think that they were grossly negligent in their representation. I think they should be removed from the case. And you know, the conversation that I want to get into that people just don't seem to really understand, if you don't practice law and you're not in a heated litigated battle, that this is a war, that you have two sides that are going to war, that both have the highest stakes possible. And, you know, in those types of situations, it's very competitive, and both sides look for competitive edges. Both sides are trying to win the case. And for anybody to think that Nick McClelland didn't think that he was getting out lawyered, and love or hate the memo or the purpose behind it. And I will be the first one to acknowledge that part of the purpose of that memo was certainly to get their theory of the case out to even the playing field, which to me is fair game. You may not like it out there, but I think it's unfair that the state gets to put a PCA out, and where they paint in every case, the state, why should the state be able to put their case in chief out to the world, to the public, for years prior to a trial actually taking place? And that's all the public hears about. That's why everybody thinks everybody's guilty on the front end, because you're only hearing one side of the story. You're hearing the state's theory of the case. So in this case, like, when they did it, I thought it was brilliant. I loved it. I loved when they did that. Like, first they did this little letter memo where they're like, hey, Richard Allen's innocent, and these are all the reasons why. And then they did it again with the big memo, you know. Now, like, and that's why I'm saying I wish they wouldn't have put in the gratuitous violent stuff in there, because that got people so enraged that they lost sight of what the thing was really about, which is a shame. You know, and there was a very interesting interaction between Rosie and the judge, where he says, well, I know you're upset about the memo. And she said, I didn't say a thing about the memo. The memo is not one of the things that I listed in the 4 things that I listed. I didn't say anything about the memo. She got real defensive. It was like probably the biggest moment in the entire day when she said that. Like, when Rosie brought up, I think that because we had been insinuating on her that she was super irritated about the memo.
Left my pen.
All right.
All right.
Sorry,
Mute.
I'm going.
So that was a very interesting thing that happened in there. And the judge adamantly denied that she was in any way, shape, or form upset about the memo and that it was originally filed public, which brings us back to the writ of mandamus. The writ of mandamus, the entire point of that was to say this is a public trial. This case is not under seal. They had no obligation whatsoever to file that under seal. And people are like, oh, well, would you have done that? Yes, I would have 100% filed that publicly because it's a public trial. We have a right as citizens to see what's going on in these cases, and that's the entire point of it. Whether or not you take umbrage with what was contained in that memo is a different thing altogether. But whether or not they had the right and they did the right thing by filing it publicly, without question, they did. They should have, and they did. And then Gull, when she took it off the docket within 3 hours, I mean, that spoke volumes about what her mindset was on it. And then she admits that she still hasn't, like, why she hasn't set a hearing date. She's like, I haven't even gotten through the entire memo. Like, I don't know if she was saying that to try to prove her point that she.
So I think I'm going to have to leave you. I got to deal with some stuff.
Okay. I'll try to keep it going without you. I'll see what I can do. But come back. So after that goes down, we're left with the situation where basically that's it. You know, McClelland says his piece and they're starting to mill about, and the judge asks a question. Well, when are you going to turn the discovery over? Talking to Baldwin and Rosie, and Baldwin says, I don't know, end of the week, I guess. And she's like, oh, that'll be great. That'll be great. And, you know, and she said it, and somebody had messaged me about, there seemed to be some confusion about one of the news agencies in Indiana reporting that they were still on, that they were going to be helping. No, what she asked, she said it would be nice if you would help catch new counsel up to speed. They're out. They're out of the case. Now, the question of whether or not she could do it has been answered. She did do it, so she can do it. The question is, will it stand? And that's where we're left with. Will it stand if it moves up the chain? And that's where it gets interesting. So before they ended, Hennessy, who's sitting next to me, he's like, Andy, you know, and he tries to go into the well of the court. One of the like SWAT dudes stops him. He's like, I'm Andy's attorney. I have to say something to the judge. And they won't let him into the well of the court. I'm watching this whole thing develop. He goes back behind Andy. He's like, tell the judge I want to say something. So Baldwin stands up. He says, Your Honor, my attorney, David Hennessy, who's very respected, a highly respected guy. You know, he wants to address the court. So Hennessy proceeds. She says, of course, let him come in. He steps in, and then he basically goes through his soliloquy, you know, where he restates the things such as, you know, that this has been a violation of Richard Allen's Sixth Amendment rights, that there was no notice, there was no due process, that she's pulled everything off the docket, that everything has not been on the up and up, and that it's, you know, and he goes through the entire litany of what he had addressed in his original memo when he filed that on behalf of Baldwin, when Baldwin said he was coming back in. So lays that out. He says, I have no, you know, I don't believe that Your Honor is going to change your mind, but I wanted to make a record. And again, that record's important. And that the record is what we're talking about almost all the time with respect to this phase of the trial. So this pretrial phase where this kind of stuff is going on. Again, when an appellate court is going to review a case that's under appeal, this is all they have to go by. They have the record in terms of transcripts from what went on in hearings, and then they have the docket, which is where that writ of mandamus came in, just flame throwing the judge because their docket's ridiculous. I've never seen a docket like that ever in any case, like in any county, in any state. I've never seen a docket like that. Like everything was happening in secret, and it's just not how it's done, you know? So So he basically leaves it at that. And there's one other thing that, you know, I wanted to talk about with respect to that is that he then runs back to his office and ends up filing this thing, which I'm going to throw up there. And oh, now this thing's up here. Hold on. The thing I tried to put up the first time. All right, so okay. Let me pull this guy down. Sorry. All right. Okay, let me try it again. Okay. All right, so he files this thing at about 1:00 this afternoon. And let me blow it up for y'all. So Hennessy runs back to his office, and you could tell there's some typos in here. He pounded, like, because all these guys were furious. Like, Rosie was furious, Baldwin was furious, Hennessy was furious. And, you know, I mean, they like, what I thought was going to happen today is I thought that she was going to basically say, okay, well, you've entered your appearance. Now I'm setting a hearing date for the motion to disqualify you, like, tomorrow. And then she was going to go and do what she was going to do on the 19th and then get it on the record. I mean, that would have made sense to me in terms of her trying to perfect the record and her trying to follow the law. You know, even if it had to be next week, here, I'm giving you 7 days notice. We're having this DQ hearing next week. Good luck. Because they already know what she's going to do. Like, there's nothing that they're going to be able to present to her that's going to change her mind. In her mind, they're dead to her. They're not getting back in unless somebody forces them back in. So I'm going to read it real quick. So he says, comes now David Hennessy, attorney for Baldwin, and supplements the record, which is what I was just describing to you, made in open court today. So that's when he came up at the end and was saying things. So, you know, and one of the things that he was saying to kind of like supplement this is that they would have had a hearing and that he would have had witnesses from all these different agencies talking about, in addition to the witnesses referenced in open court, undersigned would offer into evidence the performance guidelines of the Indiana Public Defender Council and the applicable guidelines from the National Legal Aid and Defenders Association, the National Association of Criminal Defense Lawyers, and the American Bar Association. They would also offer the affidavit of Mitch Westerman, who said Mr. Baldwin absolutely had no knowledge of any leaks. And that was the guy who pimped the stuff out of the office. Number two, the witnesses referenced would have testified as of their credentials, their knowledge of all applicable guidelines, and that upon a review of the pleadings filed, the investigation performed, in the representation in court hearings, attorneys Andrew Baldwin and Jay Rosie surpassed all applicable guidelines and rendered zealous and effective representation of Mr. Allen. And that was his bigger point, which was, this is what it looks like in terms of a defense team or a defense lawyer zealously representing a client that they believe is innocent. So all you people out there in this world that think that this is all some kind of ploy, or that this is Rosie trying to get a Netflix deal, that it's not what this is. This is what zealous representation of an innocent man that they believe their client is truly innocent looks like. This is the kind of fight that you put up, and it's sometimes not pretty. But I would just ask you if you could try to pull it, if you're in that camp of, all right, look, I think that they planned all this. I think that this was all like an intricate plan to get those pictures out, to bolster their memo, to poison the jury pool, to get them thinking, you know, whatever, that this guy's innocent. And, you know, like, I mean, again, it's the PCA. It's evening the playing field to the PCA, but forget about that argument even. Just, I want you to try for one moment to think about the concept that Richard Allen actually is innocent. Just, even if you have to, like, even if you're sitting back in your chair, like, oh, just pretend for me. And if you're of the mindset that he may be innocent, this is what it looks like when you're fighting for somebody. Don't you think this is how hard attorneys should be fighting for somebody who is actually innocent? Do you think that they should be sitting idly by, playing nicely, just letting the process chew up the defendant and spit him out into prison, only to try to battle for 25 years to get a wrongfully convicted man out of prison? This is what zealous representation, which is our duty. It's our duty. Read, pull up the rules, the ethical rules and the duties of attorneys, especially defense attorneys. It is to zealously represent our clients, and they use the word zealous. Check the definition on that. This is what a zealous defense looks like. I'm sorry if you don't like it, but that's what it looks like. So the applicable guidelines rendered zealous and effective representation to Mr. Richard Allen. Witnesses would also have testified that continuity of counsel, which Allison was talking about, is always a crucial consideration, and any interruption of which would rarely, if ever, be in the best interest or of the accused or of the families of the victims, who now, because she has pulled these guys off the case, and I know there's you people out there saying, well, they deserved it. Well, you don't know that because they never had a hearing. Because if they had a hearing and they would have put on some evidence, I might have switched. I might have been like, yeah, these guys, like, this is a nightmare. But because I didn't have the ability to be able to hear any witnesses at all, or the circumstances under which this happened, I don't know. And anybody who's pretending like they do is jumping to conclusions without the benefit of having heard any of the evidence of it. That's where the weight is of the Sixth Amendment right to counsel against her DQing somebody without having a hearing. That's what the argument is here. It really is. So there would also be testimony on paragraph 4 that an unnecessary continuance forced by the judge would not be in the best interest of the accused. And then my favorite paragraph, of course, is that there would also be testimony that that person being Judge Gull, we can assume, that has never practiced criminal defense, is not competent to judge the effectiveness and necessities and quality of criminal defense representation, nor what representation is in the best interest of an accused. You take that for what it's worth, and I take it for a lot. You can't know. It's like I've been saying this about Brett, the same way that I don't know anything about prosecuting a case. He doesn't know a damn thing about defending a case. He doesn't know what it's like to be on the defense side of it, with the weight of the world against you, with all the resources and the power of the state bearing down on you as a defense attorney and your client. It's brutal. And it's a valid point. How can she know? You cannot know what it's like to be on that side of it unless you've done it. You could guess, but you can't know. I would never presume to know what it's like to prosecute a case because I've never done it. But on the defense side of it, it's even more intricate because you're dealing with the human that they're trying to convict. It's a whole different element. Frankly, prosecutors are dealing with witnesses the entire time, trying to get their case ready for trial. We're dealing with witnesses and the defendant, who's the one being tried. It's a very, very different circumstance. It really is. So as much as people want to say that that's just snarky BS, there's a lot of truth to it. And, because that was one of the things that Allison and I were talking about. It's not the role of a judge for her to decide whether or not she thinks that their theory of defense is good or bad. It's not her role. Her role is the gatekeeper. She is the gatekeeper of evidence coming in. She's the gatekeeper, and she is the arbiter of the rules of evidence as they apply to trials. She rules on objections. She rules on motions that evidence is trying to be either suppressed or it's tried to be put in. That's what her role is. If it's not a bench trial, she's not the trier of fact. She doesn't get to decide whether or not she thinks somebody is guilty or innocent unless she is the trier of fact, meaning it's a bench trial, not a jury trial. She has a very specific role, and not included within that role is for her to make determinations whether or not she liked the theory of their defense, and it's going to be interesting down the road to see how this plays out. Because I'm just telling you, this thing's not done. It's just not done. Like, they're not giving up. They're not going away quietly into the night. And I'm sorry if that's depressing to people. I think it's incredibly unfortunate that it's delaying justice for the girls. But I honestly think it could have been avoided. Do I wish that the leak hadn't happened? Do I wish that this guy wouldn't have walked it? I mean, at this point, we know it's definitive that Baldwin didn't hand over discovery to this guy. Like, the guy came in and stole it and took pictures, and no one knew about it from that office. So again, it's a reckless argument. So you have to argue, does that recklessness, in terms of him having that accessible to people when he's out of the office or whatever the time that happened was, does that outweigh Richard Allen's right to his choice of counsel? Because the other three things, like the two of the things that she brought up were them arguing about his civil rights in terms of the confinement in Westville. I mean, really? I mean, that's part of your role as a defense attorney. If you think that your client is being mistreated in a prison, you have to bring it to the court's attention. You have to try to litigate it. I mean, like, for her to say that that was gross negligence was bizarre to me, frankly. I didn't even understand why those were included on there. It kind of reminded me of when the ARDC in Illinois was telling us that we shouldn't have hired a polling company in Omaha, Nebraska to poll the citizens to see if they had already formed an opinion, because they were trying our client in the press for 3 years every day. So we hired a company to ask 5 questions. They called random people in the county and they asked, have you formed an opinion on do you know who Anthony Garcia is? Have you formed an opinion on the case? If you have, what is that opinion? And, we got the results of it, and it was stunning. Like, it was 90+% had heard of the case. Of that 90%, like 90%, 90 of 90% all thought he was guilty. It was like, to me, it was definitive evidence that pool was tainted, and it should have been a change. Like, we were doing it for a change of venue, which got denied, and it was tried in that county. I mean, that's the kind of stuff that just goes on in cases from the defense side of it, where we lose motions way more than we win. And it's not because of good lawyering. It's because that's how the system operates. It's built to convict. It just is. So, all right, I want to get to some questions. Thank you guys for being patient. Sorry for the hiccups. I hope you still love us. All right. Okay. So, okay. So somebody put this, it's not really a question. It says, I'm now on your side of due process. People in RA deserve to hear the entire case of negligence against Baldwin and Rosie, but Baldwin needs to be disqualified. Kate, I don't necessarily disagree. And I know you and I have gone at that little point there, but like Rosie, he didn't do anything. And these guys have separate offices, and it was one of those things. Oh, and that was the other thing that I want to bring up. The one other thing that Rosie did say is that because she asked him, and it's an important point, and I apologize for forgetting it. She asked him, so what has changed since the day that you guys withdrew? What's changed in the last 12 days? And what he said ultimately was, what has changed primarily is the fact that the defendant didn't get due process under the law ever. Like that changed. Like he wasn't in there for that hearing, and there was no hearing. So, and beyond that, it was his position that everything had changed by way of them entering their appearances as private counsel. So, yeah, Kate, like, that's why we had to have the hearing, like, because you have to weigh that. Like, say, for instance, it came out that Baldwin was just sloppy or reckless, that he should have had it locked up. He didn't. He foolishly trusted the people in his office that they would never do that. And mea culpa, he screwed up. Does that fact that, and again, we can't pretend that the leak wasn't contained, because it was. I mean, like that's a fact, because I haven't seen it. I haven't even been really offered it at this point. You know what I'm saying? So it's like, and I'm pretty involved in this case. You know, I know Snay and Murder Sheet, and I don't know, this Greeno guy is claiming that he's the third one. Like, I don't know. That guy's full of shit. So I don't know if that's the real thing. But you know, I mean, the fact of the matter is, you know, had this gotten out to the entire world, it's a different evaluation for certain, you know, because then we're talking about a very different thing. So I don't know. I mean, that's why there should have been a hearing. And that's why I was hoping that if she was going to, she was gonna run a move today, that it would have been to have that hearing set, and then, you know, have the hearing and have it done on the record. And it protects her as well. Like, I mean, there's no downside. She already knew which way she was going to rule. I don't think like anything that Hennessy's talking about in this thing would have persuaded her to change her mind. She had made up her mind. And it's very difficult to get a judge to change their mind once it's made up. Ariel, thank you so much for the $10 holla. Current 3L here. Love hearing points of view. Interned with the DA's office last year and learned I'd rather be forced to wipe with sandpaper the rest of my life than ever be a prosecutor. I'm my type of gal. I mean, look, I've got friends that are prosecutors. I've got very good friends that are prosecutors. It's a different mentality. It really is. It's a very different mentality. I could not go to the other side, but I know there's a lot of prosecutors that come over to the defense side. It's a strange thing. All right. And remember, I'm going to do like the shout outs for all the new members, like at the very end. I just want to try to get some questions in here. Okay. Charmaine's bringing up Gacy. Come on, Charmaine, stick to Delphi. What are you doing in the Gacy case so important? What you're doing in the Gacy case is so important, but your knowledge and platform in this case is, I take it back. Thank you. I appreciate it. And frankly, I had a lot of people come up to me today that were, you know, saying that they really appreciated what we're doing here. And look, I have my feelings, but I never reach a final decision till trial. But like, in terms of just trying to get out to the people what's actually going on without really having a super strong opinion on it, I mean, is important. Like, you know, in my opinion on it is that what happened with the leaks, that none of what she suggested is enough for them to DQ, that it's going to outweigh his Sixth Amendment right. That's just my opinion on it. You know, and there's going to be higher courts that are going to be ruling on that issue down the road. I mean, because I'm just telling you, it's an issue, and it's going to be an appellate issue. And as Allison said, I think it's an automatic remand. I think that if they convict Allen, that he's going to get another trial, and then you can, you know, everybody will be blaming the lawyers, but it was really Gull because she just didn't handle the case properly. I'm just telling you, look at the docket yourself. Like, pull up the docket and say, go on to cases of interest in Idaho, pull up Koberger's docket, and then pull up the docket in this case and compare and contrast what those two dockets look like and what the orders say and what the hearings are set. That's what the Koberger case is, what a proper docket looks like. It's what a normal docket looks like. That is on her. Entirely on her. No one else can be blamed for what that docket looks like. Okay, love you guys. How can I become a member? Can one of my mods let Mary know how to become a member? I think you have to do it on a computer. Like, I'm not sure if you can do it on a phone. Because I have my StreamYard screen up, so I'm not on YouTube, so I can't see the buttons, and I'm old and tech stupid. So, all right. Not really a question, but a statement and a $5 holla. Thank you very much. This is all such bullshit. Makes me so angry. This isn't justice for Abby and Libby either. By the way, is this the verdict? No, Jedi Platypus. This is not the verdict. Not yet. Lone Pony. It sucks that justice for Abby and Libby has been delayed again. I agree completely. And it didn't have to be. Thank you for both your insight and enjoy the show. Thank you very much. And thank you for the $5 holler. I really appreciate that. Allie and I both do. Carrie RH, attorneys working the case for 10 plus months and say they'll be pro bono, yet judge would rather citizens pay. That in and of itself stinks, as well as everything else. I agree. I mean, that's a good point. I didn't even think of that point. And thank you, Carrie. Is that pounds? Did you send me £5? Woo! Thank you for the £5. Appreciate it. Oh, Thomas with the $20 hollow. I appreciate you, man. Putting correct process aside, how is the judge supposed to balance a defendant's preferred counsel versus the potential for appeal due to that counsel's actions? Seems like an appeal would come for removing or failing to remove. That's a possibility. But, I mean, you have to look at it like this. The state doesn't get to appeal if he's not convicted. You know what I mean? Like what under what circumstance would the defense, I mean, I guess I could see a world in which they're coming for ineffective assistance. Because typically I think it's better not to have your trial counsels as your appellate lawyers, because typically, as a defense attorney, you have to have thick skin because you need to understand that when they're appealing, that they're going to throw you under the bus because they have to. I mean, they're trying to get a retrial. And if you screwed up as the attorney, they deserve a new trial. I mean, most of the times the judges are going to I don't find it adequate. So yeah, I mean, that's an issue. It's a valid point. But I think in terms of the weight, they're always going to weigh a constitutionally protected right more than whether or not these guys screwed up in terms of how they represented him. So, I mean, ultimately the right's going to win over the other issue, but it's an excellent point. And thank you for that $20 holla. Christina, $5 super sticker. Appreciate you, girl. Really appreciate you. Hi, my name is pronounced Kausha. Did I pronounce it right? I hope so. I know you were worried to F it up last time. LOL. I appreciate that. I really do. The motion to disqualify Gull was filed before the suspect removal of the attorneys. Doesn't this matter? In my world, it does. But she's the law of the case. I mean, she's the judge. Look, I mean, she can do whatever she's going to do. She's the judge. If she says you're out, you're out. Like, pounding your fist and stomping your feet and crying, it doesn't matter. She's ruled. Whether or not she was wrong about it is going to be an issue for appeal. And now whether that's going to be an interlocutory appeal, which means an appeal that takes place during the litigation of the case, or whether or not they're going to file another writ, or whether or not they're going to try to kick it on a writ of habeas corpus and go to the federal courts, which they might do. Those are all possibilities. There's a lot of things. And again, I'm telling you, this thing's not over with these two guys. And I just want you to understand that no part of me thinks that this is some long play for them to get a Netflix deal. It's just not a thing. That like I've said it, and I can't remember if it was the last live. Like when we took on the Garcia case, it lasted 3 years and it absolutely destroyed our business. Our revenue stream just dried up because we couldn't take on new clients because this thing took up all of our time. And this case is the exact same thing. It doesn't make any sense. If they're making $450,000 a year at their practice and you're trying to get a Netflix deal, documentaries don't pay jack shit. They don't. Not that like that's not the budget that they put money into. They have to pay actors for scripted stuff. Like I know I've gone through it with the Gacy stuff. I pitched this to 30 different production companies, including like big ones like Blumhouse, and I know what they were offering. It's not the kind of money that like that concept is just ridiculous. Oh man. Casa was like crushing the game here. All right. So Another $5 holla. What's the legal procedure for a judge to remove a lawyer for gross negligence? Is written mandatory? I mean, to be honest with you, if you're looking through the rules, I don't see. I mean, she's got the right as the trial judge. If she feels that a lawyer, it's within her discretion. If she feels that a lawyer is truly not acting in the best interest of his client and is acting in a way that is really prohibiting that person from getting a fair trial, she's going to have the ability to pull them. The question of whether or not it was gross negligence is why you have the hearing. So I'm not an Indiana lawyer. Like, if we have any Indiana lawyers in here, and I would love if you'd put, I don't know if they have a statute specifically requiring a judge to do that. So, but best practice in terms of the appellate record is going to be for her to have a hearing, because how do you determine what's gross negligence? I mean, you're leaving a lot to the imagination in the event that you don't have a hearing, because the appellate court has nothing. Wow. Is that your Halloween haul? Wow. Look at this. Okay. So it is Halloween, y'all. So,
happy Halloween, guys.
That is way too much candy. No.
It's because me and my friend went around the place.
Okay. All right. I love you. Come on. Get off. I love you. Give me a kiss.
Let me find you a piece.
All right.
Let me find you a piece.
I don't want a piece.
What's
You know,
your
I don't need
favorite?
candy.
What's your favorite?
Okay. So, I mean, the best practice would have been 100% to have a hearing, because then a record is made, and then she's establishing what she determined to be gross negligence. Because when she doesn't do it, there's really no record of it. Like, there's still no record of it with respect to those, 4 points that she put on that thing. It was never on the record. So, I like, maybe there's somebody in the chat that'll help us out with that. This is an Allie question. Is mom back?
She's downstairs.
Oh, is she not jumping on? Maybe she's not coming back.
Do you want me to ask her?
Oh, okay. So she asked. So that's the same question. Kasha, you asked the same question twice. All right.
Yeah, guys, stop it.
Yeah, ask mom that question. Maybe she knows the answer.
What question? What question was it?
Tell her to just jump up back on, and I'll let her off in like a few minutes. All right. $2 holla, buried in Oklahoma. Thank you so much. I appreciate that. C Star, thank you so much. Was the original leaker punished? No, I mean, they weren't punished. I mean, and frankly, Alice and I were talking about, I don't know what criminal statute they could be tried under. Maybe trespass. Like, I'm talking about the original guy, because that obviously went beyond the license of what he was able to do in that office space. But there's not much. This isn't like a WikiLeaks. These aren't classified documents. That's what I'm saying. This isn't like some federal case like what they're doing with Trump, like where he's got classified documents that he took out of the White House. This is a case with a protective order of photographs that are ultimately going to end up being put into evidence at trial anyway. So I not that I can think of. I don't believe there's any real avenue beyond maybe a trespass. I mean, I think what could happen, but it's not criminal, is that Judge Gull can say, okay, you worked in the office. Baldwin made you aware of the protective order. I'm now filing what's called a rule to show cause. Hey, you got to take that out of here, please. Like it's too crinkly. Oh, good. All right. So are you aware, like it was the question that I was asking that we were talking about before. Are you aware like of what the procedure is? Because we were talking about, we wanted to pull up case law on that.
Yes. Yeah, so I don't know what the procedure is, that is basically what you've been talking about as far as, her setting out what her issues are and giving them the opportunity to respond and be meaningfully heard. But what the standard on which she can do that, I haven't had a chance to look at. What would typically happen is a judge would file something called like a rule to show cause why they should be disqualified. But, technically they can just let them know, which they have done now, like what their issues are. But I think a rule to show cause outlining, this is why I think that you're grossly negligent, assuming right now that gross negligence is enough. But what I don't know is what constitutes gross negligence, and if gross negligence under Indiana law is enough to disqualify counsel of choice without limitation and without regard to, what, any conflict or issue that the defendant might be willing to waive. But either way, she needed to allow them to be heard.
Yeah. I mean, it's best practice, I mean, like, how is she ever going to establish what was gross? There is no record of what she considered to be gross negligence for the appellate court to decide the issue.
Well, I'm sure that she'll have to, there's certain things where there wasn't a record, where the judge writes something up, the parties all agree, like you do something, and then that gets placed in the record.
The bystander statement?
Something like that, right? Yeah.
All right. And I didn't want to leave this. So like we were talking about, I was talking about maybe, maybe there's a trespass, but like the more obvious thing is, a rule to show cause for, criminal contempt of court. So, which she could throw the leaker in jail for a criminal, because like theoretically that person was in the office and they were under the protective order. So they violated it.
Right.
Hopefully, so
I think it's still not I can't think other than trespass, and maybe I'm just not, thinking of something, because it can't be tampering with evidence, so I don't think there's an actual crime on the books that this would fall under other than trespass.
Right.
But,
that's why I was saying the rule to show cause is the better avenue. And then she can throw him in jail for that, like not for, for a limited period of time. Okay. And thank you for that $2 Hollis Star. Desiree, question. I may be overthinking it. And babe, you don't have to stay on. I know you're trying to finish that thing. I just wanted to pull you on for that question because I thought maybe you'd know better.
I think well, I'll answer. We'll read her question and then I'll answer, give my opinion on it, and then I'll get off.
All right. Question. I may be overthinking it, but doesn't the newly appointed counsel have a duty to speak to RA's right to counsel and due process?
I absolutely would say yes. And, I was, talking to Bob about, a way to communicate to him that that's something he should, not like us directly, obviously, but that someone should communicate to him that is something he should absolutely positively demand to his current lawyers and even place in writing.
Okay. Yeah, and I agree. And like we brought up,
they waive it. So, well, you can't really waive if it's what we've been calling structural error. It can't really be waived.
Right. And well, we were talking about the interlocutory appeal and like who would have to file. Would it have to be these two new guys? Which is weird. Like if because we were talking about, well, if Richard Allen said, hey, no offense, but I want those guys back, and I'm asking you, like I'm telling you to write, like I want you to file an interlocutory appeal to get them back as my lawyers. Obviously, if those guys want to be on the case, they're going to do it begrudgingly because they have to, because they have a duty to their client. But still, it's a very weird circumstance.
Yeah. But since their appearances, Rossi and Baldwin's appearances aren't of record, they can't file anything in the circuit court, and a notice of appeal would start there. But I guess they could do something similar to what the lawyers did in that writ, where they said, like, I know we're supposed to usually do this, but we can't produce that because the judge isn't putting the stuff on the record. Something
now I'm talking about the new counsel. The new counsel would have.
No, what I was saying is that, yes, I already said yes, they should and have to do it. But if Rossi and Baldwin wanted to do it, they don't have the ability to do it because that pleading is a pleading that starts in the circuit court, and she's not recognizing them as counsel. But maybe there's a way to go up to the Supreme Court and ask them to docket it directly, because his counsel of choice isn't being given the opportunity, but I don't know that would work.
Right. I mean, it's a real challenge because they're not a party to the case anymore. How are they heard on the matter? Like even moving forward. Because like one of the things that
They don't get heard on the matter until this changes.
Right. Exactly.
That's what I said the first time that the judge said, that's it, you're stricken, you're removed. That they won, she won because they can't file anything unless they entered their appearance as private counsel, which they did, and then she did it anyway. So
right.
All right, bye all. I'm sure
All
Bob will answer everything perfectly anyway.
Thanks, honey.
Okay.
All right, $5 holla from Samantha. Thank you so much. Thanks for all you do. Do you think that Baldwin and Rosie should have approached the withdrawal issue differently, i.e. opted for the public shaming hearing? I mean, no. And the reason I say no, and not because of the public shaming aspect of it, like the problem is that they knew what the result was going to be because the judge told them as much. Like, because once you're DQ'd from the case, it's way harder to ever try to get back in. Like, had they been DQ'd on the 19th, had they had the shaming hearing, and she told them flat out, I'm DQing you. I'm going to bring you out there. I'm going to go through my list and I'm going to DQ you. It doesn't matter what evidence you put on. I've reached my conclusion and nothing is swaying me from that. So for that perspective, and one of the other things that Baldwin, or no, it was actually Rosie, argued today, was that the reason that he didn't do the hearing was not to avoid the public shaming, but that, and this is true, and I think that the detractors are going to be like, oh yeah, right, but it's true. They didn't want this all coming out to the public because it would have hurt their client, because it would have put things out there that were going to cast a negative light, not just on the attorneys, but on Richard Allen as well, because things would have come out in terms of the evidence and, what was actually leaked and, various other things that would have been testified to. And that all reflects poorly on Allen, where he's already up against it. Like, and that was one of the reasons that Rosie said, that's why we didn't do the public hearing. It wasn't so much as I was concerned about the public shaming, because as to Rosie, he didn't really do anything. Like, honestly, they're lumping them together as if they're a two-headed like monster, but they're not. They're two separate lawyers with two separate practices that just happen to be trying the case together. So, like this whole lumping together, like Brad's got to be like, man, I got screwed on this thing. I got lumped in because, he was sloppy with the discovery, and she casted shade. I mean, like, it's on the record now that she's had a finding that they were both grossly negligent, which is not a good look. It's like, it's such a huge finding, like, and it's such a career affecting finding where neither of these guys have ever had any kind of issues with the disciplinary commission at all. Okay. So, and thank you. If I didn't thank you already for that $5 holla. All right. Amgam. Can he be moved to a different, so the answer is yes, he could have been. The judges decided no, he won't be. So they brought it twice. Okay. So there's facility like Cass County was perfectly suitable. She denied both times they tried to get him moved. She's not moving him. So it's one of the issues. And that's one of the things she brought up as, like she just thinks that they're lying about things. And so does McClelland. Like, he said it as much. He said they lied in the memo. We didn't get to hear what he was saying they lied about, but he's claiming that they lied. Lillian, thank you for becoming a member. We appreciate you so much. $10 holla. Please explain what happened to the Franks. So that got entered and continued today. So that is still a pending motion. That motion is still out there. Now, whether or not these two new guys, because if Baldwin and Rosie are going to proceed to try to get back into the case, the case is going to keep churning forward. Okay. So when these guys get to that point, when they start digging into the discovery, if they're like, man, we're not feeling this Odinism thing, we don't think that these alternate suspects are valid, which I can't see them ignoring the alternate suspect thing. I just can't. It's like they're defense attorneys. If they're worth their salt, if you ever have an alternate suspect that has admitted to being at the scene, you got to let the state deal with that at trial. I mean, you bring it up. Like, let them say he's got the IQ of a 7-year-old or a 7th grader or whatever it is. I mean, it's a guy who's saying he was there and that he left DNA on one of the girls. I mean, like, how do you ignore that? I don't like, every time I read some like people ignoring that, it's so bizarre to me. I mean, like, what world are you living in that you're ignoring somebody who's admitted to being there the day the girls were killed? It's strange. It's in a police report. It's not Baldwin and Rosie making that up. All right. So that's going to get heard at some point. Now, whether or not these two guys adopt it, they don't have to. They're not obligated to it. But if they find the same things about Liggett lying to get the warrant, I'm assuming that they'll proceed with the Franks hearing, because they should. If Liggett changed what the witnesses said in order to get the warrant, it should definitely go to hearing, and the judge will probably rule against them. She is definitely a prosecutor-friendly judge, and she was like I've told you guys, anybody who's been on the streams before, I mean, Gull, like, that's the track for most judges, the prosecutor's office, so you get a lot of prosecutors or former prosecutors up on the bench. That's just the way it is. Okay. And thank you for that $10 holla. You want to know, we want to know. Charmaine. All right. $7 holla. You seem tired, Bod. I am exhausted. Take care of yourself. That said, you alluded to having some insight into Rosie and Baldwin's next move. I can't really share. I just know it's not done. And, this little thing that was filed by Hennessy gives us some insight that they're not quite done yet. What the move is going to be, I don't know, but I know that there's a lot of bright people trying to figure out what the proper move is because of all the issues that we've been talking about. It's not as clear cut as you'd think. So it's not one of those things where it's like, oh, this is the thing to do. You got to try to work through the pratfalls and whether or not it'll be successful and what you need to be able to establish in order to figure out which route to take. And you got to find standing. You got to find the ability to be able to bring the matter when you're not a party to the case anymore, which is a big issue. Smiley Kylie, thank you. Same question as above, same answer still. Thank you for the $5 holla. That Franks is still going to, in some shape or form, unless they completely abandon it, which would be shocking. If they abandon the Franks, I'm going to lose my mind. Then I'll know then any kind of conspiracy theory that might be floating around in my mind will be confirmed that these guys are her lackeys. I mean, it's like if they ignore the fact, unless, because we're never going to hear when they go through the discovery, unless they just dismiss the motion, we're not going to hear, well, we didn't find Liggett to be lying. Like, it'll just disappear it'll never come. We'll never hear it, so we would have to assume that they did not reach the same conclusion. They did not interpret it the same way that Rosie and Baldwin did. Brenda Paw, $2 hour. RA has the right to fire appointed counsel. No, he does not. Can't fire your appointed counsel. It's very, very difficult. You can't fire them. If there's a huge conflict, you can try to get them conflicted out, but you can't just like that. That's what we were talking about. That's a disadvantage of being an indigent, which a majority of defendants are, meaning they don't have money and they're appointed PDs. You're stuck typically with whoever you get. And some of them are great lawyers. Some of them aren't. And all of them are overworked and don't have the time to dedicate to the case, as opposed to, say, for instance, a private counsel. All right. I think I got through all the starred. Let me see. I think there might've been a couple up top. Just Jen, new member. Thank you very much. Jenna Sievers, thank you so much for becoming a member. It means so much to us. Hey, and I don't know what the likes are at. I hope y'all are liking. I hope you're subscribing. And I am tired, y'all. I'm definitely not 100% tonight. I hope you forgive me a little bit. You see me when I'm on fire. It's been a long ass day. I got like 3 hours of sleep because I got in to Delphi at like 1 a.m. and I got up at 5, and then it's just been a long day. So I'm trying to power through because I love you all. So hopefully you're forgiving me if I'm not quite up to speed. Jamie Lee, new member. Boom. Appreciate you. Ariel gifted 1 Defense Diaries podcast membership. You're awesome. Thank you so much. And I think looks like we got a couple more. You guys are so generous. It's unbelievable. Lillian, I don't know if I thanked you for becoming a member. I want to make sure. I don't want to miss anybody. I really don't. Christine, $5 holla super sticker. Thank you so much. I can't remember if I thanked you, but I'm going to thank you again if I did. Okay, Megan Z, $10 holla. Thank you so much. Let's rally the troops. Who do we call? Who do we email? What about a petition? Freaking protest is disgusting and un-American. AF. Happen to him can happen to any of us. There's a lot of truth to that. And stay tuned for that answer. There's things in the works. So we will try to keep you apprised of anything that I like. I'm kind of in the know. So I'm gonna be updating you guys when I'm getting updates and when I'm allowed to give updates. $4.99. Hey, Bob. A few of us are tuning in from UCL Law Library. What up? I wanted to say thanks for all the work and driving y'all are doing. No, thank you. Like, how cool is that? What L are you guys? You guys 1 L's, 2 L's, 3 L's? Do the damn thing. Come on over to the defense side. We need you. We need you. But thank you guys for checking it out. I appreciate you. And study. Remember to study hard. All right, Janet Studdard, $2 holla. Sarah Boone has gone through a few. Yes, she has. And those are all conflict issues. So it's like there's ways you can get rid of them in terms of the PD, but it's not like I just want to fire them because I don't think they're a good lawyer. Like you can't, like that can't happen. So, I mean, you can get rid of them, but it's a process. It's not as easy as you'd think. Oh, dang. Amgam, another $20 holler. I think he gave 20 before. Man, give it till it hurts. Living 40 miles from Delphi is scary if you have kids. Law enforcement said in the beginning they believe that more than one was involved, and they certainly did say that. Now we see a judge who is allowed to decide what they want with the only reason because I said so. And that's exactly what it was. Like that's the whole point of there not being a hearing to where the people that are like, they should have been gone, they could be pointing to that and they say, okay, well, this is what they said at the hearing. And we disagree with you because this is like, we think this is enough for them to have been DQ'd. That just doesn't exist because we didn't have the hearing, like that's my entire point. So excellent question or statement. Just Jen, $5 super sticker. Awesome. Amazing. Thank you. All right. So here's what I want to do. I think I got all the stickers handled. And I have promised now that Allie's off, I'll answer some questions just for some regular subs here because there are a million, like, I don't know, like it's got to be over 1,200. Like if you have a question that you want answered, do me a favor, type it in real quick. So it's showing up at the bottom of the chat. Because I do want to get to them, okay? Because I want to try to answer as many questions as I can. Professor Kate, I don't know. I don't remember saying hi to you and saying thank you. So thank you. And if I did, I'm sorry for repeating, but thanks a lot. We appreciate you joining in. Oh, all right. Pam, $5 holla and a vote for Keanu Reeves and Sandra Bullock to play you in a movie. Oh, you're the sweetest. Appreciate you, Pam. And that $5. It's the best. All right. Okay, let's see. Okay. Legal question. If you have a pot of coffee in the judge's chambers than it is legally the chamber pot that you drink out of. Excellent. And it was funny. Good job, Creed. I mean, it was technically a legal question. Okay, let's see here. All right. Okay. All right, let's see. Man, I told him at the murder sheet when Nick McClellan was my attorney, I thought that he was a snake in a slime ball. More and more people are getting to see that now. Little insider knowledge. All right, thanks for that. Little dirt on old Nick. I guess former client, not happy. All right, so that's interesting. Okay. Charmaine, did I give you the love for the 5 gifted Defense Diary podcast memberships? If not, I am now. Thank you so much. Okay, I like this. A lot of people from Indiana in here. We are worried. Well, a lot of people in the rest of the country are too, little gambler. I can tell you that. There's a lot of people out there that are concerned about what's going on. And again, that's really that's the argument for transparency in cases. It's like we can't do things under cover of darkness. It has to be out there for us. We're all grown-ups. We can handle it. We can handle the pleadings. We know that this was just the worst of all types of crimes. We know that. None of us are ignorant to that fact. I mean, we know it. So, we need to know what's going on in these cases because it matters. I mean, it's like the reason this case is so important to me is because it's really shining a light on our rights as citizens. I mean, this could happen to anybody. I mean, in all honesty, like, again, try to imagine that this guy actually is innocent, that because he gave a voluntary statement that he was there, and they've matched an unspent shell casing, which again, I'm going to tell you, and if you can check it yourself, don't believe me, find any case law in any jurisdiction in this country where they have gotten a conviction based on that. Because that, as we know right now, is the only evidence they have other than him being present at the bridge. And mere presence is not enough. So, and I've been saying it all along. Since that PCA came out, they better have more. Because that ain't enough. I forget, Sleuthy had me jump on some dude's thing today, and I forget what his name was, but, he's big. He thinks that PCA is rock solid. I could not disagree with him more. Okay, Jason, he was your trial attorney. All right, so boom, boom, boom. All right. Okay, let's see if there's any questions down here at the bottom. I'm losing people. But y'all been hanging for almost 2 hours, so I'm not complaining. I'll tell you that right now. My God, you guys have been busy in the chat. All right, I got to change that thing where my mods, and thank you to all my mods are in here. I don't even know because I'm on StreamYard. I'm not looking on YouTube, like which of my mods are in here. Whichever one of you guys are in here, thank you all so much for doing this. I super appreciate it. And when you're jumping off, and I feel bad because I've probably gone longer, but my boys over at Publicly Buzzed jump on their kick. If any of our mods have their have the link to that would be awesome. I think they're watching a horror flick over there and talking trash. Okay. I always like Travis Williams and stuff. The supplemental record of Hennessy filed today is the most significant event today. I agree. He was a chairman of the Indiana Public Defender Commission, and what he established, I think Bob is correct, is not over. I agree, dude. I think it's a very good indicator of there's more to come. Okay. All right. I'm trying to get to the bottom. Did anybody put questions at the bottom? Wow, you guys are super active in the chat. I don't even know how many comments have there been. It seems like forever. It's amazing. All right, now like this is the kind of stuff moving forward on this channel I will figure out. Right now, I mean, this is a lot. Oh my God. Let me just say I've been scrolling for 2 minutes here and I'm not even close to the bottom. Thank you guys for being, oh, I finally made it. All right, let's see. Travis is an amazing wealth of knowledge. True story. All right. And Travis, yeah, he's always got great stuff. He's a bright guy. If you need another mod at Defense Diaries, let me know. I don't see any mods in here. Oh, Angela, thank you so much. I am gonna star that and definitely take you up on that. And if there's anybody else who loves the channel and would like to make the huge sacrifice of being a mod, I'm here for it. I'm just letting you know. Christine Beck, I'm definitely worried about his safety. I think that all I take comfort in is that there's so many eyes on this case right now that if something catastrophic happened to him, then it would be a nightmare. It would be an absolute nightmare. So, yeah, that's like I have to kind of maintain that hope that he'll be okay, just because there's so many of us that are actively watching this case. Aaron, if an indigent defendant's right to counsel does not include the right to representation of his choice, Judge Gull certainly does not have the right to representation of her choice on behalf of Alan. I love the argument. You know, short of two other guys coming in and saying we're entering our appearance on his behalf as private counsel, she does. She has to appoint counsel. So she actually does. I think it's ridiculous that she gets to pick two guys from her home county, which is 100 miles away, and who clearly practice in front of her all the time. I mean, it's just not a good look. You know, I can't at this juncture, and believe me, we're doing digging into these guys and how often they're in front of her and what kind of results they get. You know, but it certainly appears to smack of impropriety. It just does. I'm sorry. I agree, Savannah. We do. Okay, Danielle, weren't the recently leaked photos already out in the hands at the beginning of the case? Yeah, this leak was out there. I mean, and she says you think that was set up by the defense. I mean, I don't know why you would think that. Are you like, I'm not sure. Are you saying that you think the defense leaked the early one too? I don't know, because I don't know when they got the discovery in relation to when that leak happened. Like that leak happened early. I thought that leak happened before they even arrested Richard Allen, which would then make your question, if I'm reading it properly, not really make sense. But if I'm reading it properly, maybe retype it. Yeah, I agree. She provided no authority. There's no record. Like she created no record. Like best practice is create a record. Give your grounds for why you're DQing them. He's stripped of his rights. Can't she be stopped? And Slimy Nick too. They were both shady AF, full transparency. Shell casing is sus too. I don't disagree with any of that. All right. John, I don't think he didn't say that he was guilty. I actually, on my Twitter, which is at defense_, and y'all, if you guys do that QR code right there, it'll give you my link tree, which has everything. So yeah, I think I don't think he said anything that insane in terms of him being guilty, because he's a lawyer and lawyers don't say that until trial. But he did say that he thought that the unspent casing and the fact that he was wearing the same clothes and that 4 people identified him was strong evidence, which is problematic in my world. Oh, I love it. Crimes under investigation. Watching from Australia. Thank you for watching. Delphi After Dark here. Started GoFundMe with Bob here. Unfortunately, you cannot use crowdfunding apps to gather funds for criminal defendants. It's a thing. Can't do it. Yeah, this is what we're hoping. We're hoping that people from all over the world are watching and are invested in this case and getting justice for all involved. All involved. That's the key. Who would leave precious gems on the kitchen table when not at home when you have a safe? Likewise, why leave case files out when a person's life is involved? That's a valid point, you know, and had she had the hearing, maybe everybody would have agreed with it. You know, I mean, that's the entire point. You know, it's like we just don't know all the facts of how it went down. Like, so we're having to speculate that, you know, that he left his precious jewels out on the table for this guy to take pictures. I don't know if that's true. None of us do. I mean, that's the point of why didn't we have a hearing? We should have had a hearing. Because look, I mean, when I hear evidence, I could, like I said, like right now, like I don't believe that Richard Allen is the correct guy. If at trial, and he's going through trial, there's no stopping that. This train is going to the train station that is ending at trial. And if the state comes up with some smoking gun evidence, then I'm changing my mind, obviously. You know, I mean, that's the point of the process. So, you know, and that's the point that I'm trying to make, that this should have gone to a hearing so that we all could have heard why exactly, beyond just what we've heard on the internet and in pleadings from different sides and, you know, emails sent between people. It needed to be a full hearing with witnesses and cross-examination and all that stuff that you'd expect from anything of this type of nature. They weren't involved in the leak. Judge Gull's language proves that too. If they intentionally leaked docs, she wouldn't say it was negligence. I think at this point that we have to come to the conclusion that they were not intentionally leaked. Okay. Like I think everybody just needs to get to that point, and then the evaluation of the issue becomes, is negligence enough to bounce her from the case? For some people, it may be. For Judge Gull, it was. You know, now again, that's what I'm talking about. Does that outweigh Allen's right to his counsel of choice? That is the issue. Yeah, Jason, I feel like Gull should have proceeded with the hearing on 1019. If she had, I think a lot of conspiratorial thinking might not be happening. For sure. For sure. I mean, it would have been laid out there one way or another. You know, I mean, it doesn't mean that people wouldn't still disagree as to whether or not it was enough. I think that argument still would be taking place, but at least it takes all the what ifs out of the equation. I mean, that's why you have the hearings. That's why you have the hearings. You know, but like if she would have had it, the argument from the defense would have been, well, we need time to prepare. We need to get our witnesses here. You know what I mean? Like when you have a hearing, there's two sides to it. Like you just don't get to do, okay, we have all our witnesses here, because they did. They had 9 cops sitting in the jury box ready to go. And that's what I'm saying. Like when she doesn't give them notice that we're actually having a full-blown hearing on this today so that they can prepare their side of it, because they have a side. You know, that's the whole point of notice. Ask a social worker. I love social workers. I was a social worker for years, 5 years before I became a lawyer. Can Baldwin and Rosie talk with RA and suggest that he ask the new lawyers to draw up a motion to get Rosie and Baldwin back? I mean, technically, there's nothing stopping Rick Allen from calling these guys at all. I mean, technically, they're not his representatives anymore, and as long as they're, I mean, that could be construed as them trying to re-solicit business. It's sticky. It's not a clear-cut answer. So, I mean, what they could do is talk to Kathy, his wife, and Kathy can pass messages. Okay, let's see. Silver lining, Bob and Allie have Baldwin Rozzi's attention. There's hope. That we do. That we do. I confirm that today. All right, so I'm going to go back to some starred. And y'all, I'm losing mad steam, so I'm sure you can tell. It's got to be obvious. I'm usually like a very perky guy, and this is Tired Bob. Brian Blunt, $2 holla. I believe Keegan Kline fired his public defender for new. Yeah, that was a conflict, though. That's what I'm saying. You just don't get to you don't get to fire your public defender. Like conflicts can arise, and I think if I remember correctly, that guy withdrew before he pled out. If I remember correctly, I didn't follow the Keegan that Keegan Kline case as nearly as closely as I'm following this. I'll be completely honest about that because I really didn't care about that case. Angela Robbins, $2 holla, and a member. How did RA look today? Is his health any better? He looked about the same. He looked about the same. He did mouth that he loved Kathy when he was walking by. So, and then he did say it's going to be all right. I saw him saying that when he was walking, when they were taking him out. So, I mean, he looks about the same. He lost a lot of weight, still looks gaunt. I mean, he still looks like a deer in the headlights every time I see him, though. Oh, man. Shiraz. Am I saying that right? I should be for a $20 holla. Now I'm off to go find the join button. Wish me luck, y'all. Appreciate you. Appreciate that huge, generous gift to us. And I think, Jen, all right, so Dawn Burke, $5 holla. This is not just the justice system for that our fathers worked for our country. Agreed. I mean, that's kind of what this is all about. It really is. It's important. This is all important stuff. And it's gotten to the point where we have to be concerned, and it's like, that's kind of the magical, like, as much as I hate the internet, I love the internet for the attachment, the connection between all of us, and the ability for us to be able to have access to information that was never possible before. Because, like, more now than ever in the history of our country, we can know what's going on. We're in the know more than we ever have been. And it's so important. It's like people don't, like, no one, if you're not a lawyer, you're not sitting around thinking about the Constitution probably ever until you need to, and that's what these things are about. That's what defense attorneys do. I say it all the time. Prosecutors do not defend the Constitution. The cops do not defend the Constitution. I mean, that's only defense lawyers. That's what our job is. We defend the principles of the Constitution against the government, because remember, that document is written to stop the government from infringing on our human rights and our rights under the Constitution. That's why the document exists, because we didn't want to have what was going on back when we were in England and the UK happening here when we created a new government. So they made rules for a bunch of stuff that the government can't do. And the only people that are out there that defend it are defense attorneys. So quit hating us. All right. All right. So I think I'm good. I think that's everybody. If I missed some questions, y'all, it's not because I didn't want to answer them. It's because I couldn't find them, because there's so many. And I had no idea. None of my mods were here. I've got like 10 mods. Not one of them showed up. I did not give them any notice, though, in their defense. So, but everyone, thank you all so much for being here. It means so much to me. I'm sorry if I was like a little lower energy tonight, but again, forgive me. Had a long ass day, y'all. And I promise tomorrow night, Maggie Freeling, who is just an absolute wrongful conviction warrior. She's won a Pulitzer Prize. Absolute badass. If you are not aware of who she is, you should 100% tune in, because she is an amazing human, and she's out there doing the damn thing every day. Her and Jason Flom, they are just warriors on trying to right wrongful convictions. So I'm like, I don't fanboy over many people, but her and Flom are two people that I 100% am totally fanboying over. So I'm gonna try to control myself tomorrow, but I'm really excited about that live. I'll tweet it out again tomorrow. I'll put it in the insiders group. And again, y'all, if you haven't, please hit that like button, smash it, smash it, smash it. If you haven't, subscribe. It's somewhere on there. I know it is. And of course, share. Sharing is caring, and that lets people know that we're out here. And for all of y'all that have hung around for 2+ hours, you're amazing. I adore all of you. You're just wonderful human beings. And I hope you learned something, because all we're trying to do here is give you just facts. Check you later.